There's a massive constitutional battle taking place today. It pits the 10th Amendment against the 14th and the 15th Amendment.
What's on your fingers?
Oh, I'm sorry. So much chalk. I've been drawing all day. Follow me. Come here.
Somebody call him out.
Oh, please. That is the biggest lie I've ever heard.
That was Anne Hathaway. Chalkboard plagiarism.
Wow.
As I said, the 10th Amendment versus the 14th and the 15th Amendment. The truth is, it was a case heard today before the Supreme Court that's called Shelby County. We'll call that the 10th Amendment case versus Holder. That's the 14th and 15th Amendment side. And the battleground, or the ring in this case, is the 1965 Voting Rights Act. It's a law that was designed to prevent discrimination in voting practices across the states on the basis of racial discrimination. Now, what was at issue today that the Supreme Court heard in this case, Shelby County versus Holder, was two clauses in the Voting Rights Act, Section 5 and Section 4. Let me explain these two to you first. Section 5 essentially requires that certain states across this nation must get permission from the federal government, the Department of Justice, before they make any changes to their voting practices, to their laws. If you want to change a polling station, you want to change voter ID, you must first go to the feds for permission to make that change in the law. Now, second, Section 4. Who's required to go ask for permission? Section 4 lays out certain states that have been bad boys in the past, who have shown a historical prevalence for discrimination. We can show you exactly who these states are on the RP. As you can see, the states in dark green are states that must go to the federal government for permission to change anything on their voting practices. The states in light green, parts of those states are required to go and check with the federal government. Now, the key here is, in the constitutional case, that many of these states were decided under Section 4 that they must ask for permission because in the past they'd required things like literacy tests. And this was essentially the purpose of the Voting Rights Act, to end this kind of discrimination, literacy tests in order to be able to vote. Those states had done things like that in the past. But many of those light green states were expanded to be included in the Voting Rights Act in 1972. And these were states where a good percentage of the people that lived in that state didn't speak English. And at that time, these states didn't have non-English voting ballots. That encompassed California, Alaska, sweeping up a whole swath of states where I don't remember exactly how many it is now, but it's something like a dozen states must go ask for permission of the federal government before they change their laws. Today, the Supreme Court is debating whether or not that requirement, Section 5, and that designation of states is an unconstitutional, unjustifiable burden on the states.
Can I give you this?
Yeah, it's okay. I mean,
you overreached, by the way.
You sacrificed.
You overreached on that because it's not even believable at this point that you drew
that.
Did
I drew that?
Yeah, not even a
Just
little.
calling you out on the three-dimensionality.
Yeah, you overreached.
I'm offended, honestly. Why would you dare accuse me of that? It should be pointed out in this case that Congress has renewed the Voting Rights Act 4 times, most recently in 2006, and it did so by a vote of 390 to 33 in the House and 98 to 0 in the Senate, overwhelmingly approved as recently as 6 years ago. So let's wade through some of the legal issues in this case. Joining us now is Horace Cooper. Horace taught constitutional law at George Mason University, and he's currently a research fellow at the National Center for Public Policy and Research. Before we dive into the legal issues, Professor, let me just ask you this. Based upon what you heard today at oral arguments, do you think Section 5 and Section 4 of the Voting Rights Act will survive and be deemed constitutional by the Supreme Court?
I think it's a very close call, and if I just were forced to pick, I would say that the preclearance standard falls.
Section 5, the preclearance standard falls. There would be good evidence to back you up there, by the way. Many have noticed that our court commonly breaks down into a 4 versus 4 block, conservatives essentially versus liberals. Those are crude terms when it comes to the Supreme Court. But that fifth swing vote, Anthony Kennedy had this to say today. He said he asked if the state of Alabama wanted to erect a civil rights monument to atone for its past sins, would it be better off doing it as an independent sovereign, or better under the trusteeship of the United States government? His point being, if these states are ever to atone for their past sins, doesn't have to happen outside of the watch of the Supreme Court, or watch of the federal government. So your prediction looks pretty spot on. Let's discuss a few of the legal issues. First of all, the argument is that the Supreme Court, or rather the federal government, must treat states equally, that you cannot designate some states as bad actors and some as good actors in today's day. Do you agree with that?
Well, that's the equal sovereignty doctrine, and it pretty much says that every single state is given the authority to act and carry out its responsibilities the same as any other state, and that this specific statute challenges the ability of some states to have that same right. So Indiana can have a Voting Rights Act, a voter ID law, but Texas cannot, only because of the Voting Rights Act.
Hey, Buck Sexton, I wanted to ask you, the way it's being portrayed in the press is they say it would gut the Voting Rights Act. But as I read this, there's still a whole lot of heft that would be left, even if they were to strike down these sections. It still would ban literacy tests. It still would get rid of a lot of sort of the odious things from the past. And even on top of that, new federal lawsuits could always be brought. Isn't this just shifting the burden away from these states? And by the way, a burden that was imposed on them in some cases 30, 40 years ago. I mean, there's still a lot of protection left in the Voting Rights Act, even if these sections go down. Am I missing something?
Well, absolutely. I think you're 100% on point. What we ought to be focused on are actual things that motivated the Voting Rights Act, those things like lynchings, those things like destroying of ballots, those things like intimidation acts, those things like requiring fees for certain people to be able to vote. Those things are always going to remain a responsibility of the Congress under the 14th and 15th Amendment to see to it that they don't occur. And they have very little to do with whether you have an at-large system for electing your city council or whether you have individual districts. That part going away isn't really going to make much change. But I think one thing we ought to consider is we ought to encourage the Department of Justice to actually focus on modern-day voter violations rather than looking at 50-year-old states and micromanaging their election decisions broadly.
Well, and to the professor's point, guys, tell me if I have this wrong. There are a couple of sort of arguments against Section 5 in particular, why it should either be reformed or gotten rid of entirely. One being, we've sort of skirted around all of these. One being, there are already mechanisms in place to address discrimination. Section 2, for example, is one of those mechanisms. 2, having a one-size-fits-all voting legislation is better. Less bureaucracy makes it easier to vote. And 3, bailing out of this government watch list is expensive, it's difficult, and the process relies on old formulas and not new evidence. It doesn't take into account new evidence of discrimination to base these new jurisdictions on.
But I wonder if Congress reauthorizing the Voting Rights Act as recently as 2006 and almost unanimously, if that shouldn't also weigh into the decision, which is to say, as a democracy, we decided nearly unanimously that we should keep all of this.
But
that's
the political cost. That's the political cost of voting in any capacity against the act.
Exactly. Justice Scalia actually spoke directly to this in the sense saying, you know, these guys will all lose their jobs if they vote against this. And I realize, I mean, this is a meaty legal topic. And we've taken a big bite out of it.
But that's a political judgment by Justice Scalia, not a legal one.
This is a political judgment, and this is the political question I have for you. Don't you think that we've reached a point now where essentially opposition to voting rights is viewed almost entirely as being something that's a creature of the right, and that there's essentially no ability for anyone on the right to propose even the mildest sort of legal restrictions in terms of ID laws or anything like that without the assumption being advanced by the left that you are antagonizing minority communities by antagonizing...
Just say what it is. You're
racist,
Ben. That's what it is. You're
away
racist.
from the
But
ballot.
yet there are states that do have voter ID laws and have passed them.
Well, that's right. I mean, the law of the land, constitutionally speaking, is in fact that ID is fine at polling stations, except if you fall into some of these categories, by the way. For these states, for them to enact voter ID legislation is not okay.
And this is about voter ID.
This is about voter ID. That's the heart of this issue. There's power politics at play here that really have nothing to do necessarily with what happened years and years ago. It's about what's happening now. There are a lot of Democrats who don't want voter ID laws passed in these states.
But that still doesn't
Amy's
get to
point,
the
Amy's point,
question.
you raise a good point. And conservatives are often preaching that we should give deference to Congress, to legislation, and this is something that Congress has reauthorized several times, but that does have to be balanced against the Constitution. And the question is self-government, the 10th Amendment. Is this a violation of that, of allowing states to govern themselves and be treated equally by the federal government?
But I think it does raise an interesting question about judicial activism in this case.
It does. Professor, we appreciate you joining us tonight and giving us your insight.
Thank you. Appreciate coming on the program.
You bet. Up next, the